we're moving on to talk about adverse possession. And adverse possession, I think, is one of those subjects which most of us know a bit about, and we have the general impression that the Land Registration Act 2002 made things a bit more difficult for squatters to be able to claim successfully. But that's about the limit of our understanding. And that's about as far as we go. Now, it's true that the 2002 Act can make things more difficult for squatters, but if the registered proprietor is not alert and fails to take the necessary action within the very strict time limits allowed by the Act, then that can result in the squatter being registered as the registered proprietor. And of course, under the 2002 Act, the squatter is not then registered with a possessory title, but with the registered title that was registered to the registered proprietor before the squatter dispossessed him. Of course, the other big change of the 2002 Act is it's brought down the period from 12 years to 10 years. So, adverse possession, the law for adverse possession was in a bit of disarray until the late 1970s. There were a number of contradictory cases, and in a wonderful case called Powell and McFarlane, Mr. Justice Slade set out a comprehensive restatement of the principles applicable. That was confirmed by the House of Lords later in 2003 in Pye and Graham, where they said in a remarkable judgment at first instance, Powell and McFarlane, Mr. Justice Slade traced his way successfully through a number of Court of Appeal judgments which were binding on him, so as to restore a degree of order to the subject and to state clearly the relevant principles. Although there are one or two minor points on which, unlike Mr. Justice Slade, your lordships are not bound by authority and can therefore make necessary adjustments, for the most part, the principles set out by Mr. Justice Slade cannot be improved upon, which is why Powell and McFarlane is the starting point to an understanding of adverse possession. And basically, in Powell, Mr. Justice Slade made it clear that to establish a claim in adverse possession, the claimant squatter needs to show two things. The first is that he was factually in possession of the disputed land, and the second is that he had the necessary intention to possess the disputed land. In the cases, the intention to possess is often given its Latin name, animus possidendi, because that sort of sounds more formal, doesn't it, and more impressive, but it just means the intention to possess. So let's look at the first of these, factual possession. With factual possession, Mr. Justice Slade explained in Powell that everything must depend on the particular circumstances. But broadly, I think that what must be shown as constituting factual possession is that the alleged possessor has been dealing with the land in question as an occupying owner might have been expected to deal with it, and no one else has done so. So, distilling that down, if it's garden land, has the squatter used it as a garden? If it's a carport, has he parked his car on it? Has he used it as the occupying owner might have used it? And of course it leads to the case that everyone always quotes, which is Red House Farms and Catchpole, which was marshy farmland, and the claimant got adverse possession by shooting over it. Now, actually, if you read the case carefully, what that meant was conducting shoots over it. They were walking over the land, beating the land. But the Court of Appeal said, that's all the land's good for, and they were doing it for over 12 years, therefore they get adverse possession. The fact that you actually have to go onto the land was emphasised in a rather odd recent case called King and Blair against the incumbent of the parish of Newburn, which was a decision in 2019 of the upper tribunal, which was an argument about the ownership of a family burial vault under a church. The family owned the burial vault, the church had been closed, and the church authorities wanted to say they got possession of the burial vault by adverse possession. And although the first-tier tribunal agreed with them, the upper tribunal reasserted the normal thing that if you haven't been in the vault, you're not in possession of it. And you haven't used it as an ordinary owner would use it, which is for being buried there, I suppose. So, with adverse possession, first question is, Are you using the land as an occupying owner might use it? Then at the same time, you have to have the necessary intention to possess. Now, until the squatter has actually extinguished the title of the registered proprietor, their position is clearly precarious, because if the registered owner turns up, they're going to get hoofed off. So to some degree, animus possidendi has to allow for that. And so what Mr. Justice Slade said in Powell and McFarlane was, what is really meant, in my judgment, is that the animus possidendi involves the intention, in one's own name and on one's own behalf, to exclude the world at large, important, including the owner with the paper title, so far as is reasonably practicable and so far as the processes of the law will allow. So your intention is to exclude everybody, the world at large and the owner with the paper title. Important though, you don't get intention to possess by saying I intended to possess. The court gets it from what you did. So if you go on the land and plough it up and seed it or build on it, that's a pretty good indication you're intending to possess it. However, if the acts are equivocal in the sense that they could show adverse possession but they could equally show something else, then you do not have the necessary intention to possess. The obvious case on that is a case called Wimpy and Soane, where they built a fence, erected a fence around the land, but that was ambivalent because it could have been just to exclude the world at large on the rather odd facts of the case, and not necessarily the owner with the paper title, therefore held to be equivocal and not sufficient. Now, a squatter who believes he is a tenant has sufficient intention to possess. You don't have to believe you're the owner, though that's changed under the 2002 Act, and I'll look at that in a moment. But under traditional adverse possession, all you have to do is intend to possess the land. So, coming to the 2002 Land Registration Act, as Mr. Justice Lewison, as he then was, set out in Wells and Pilling District Council, the changes made by the 2002 Act have seen a move away from what was called registration of title to what is now sometimes called title by registration. If you're registered, you're the owner. And that's the case even if you got there by fraud, unless and until it's undone. If your name is in the register, you are the owner. Now, as a result of that, when the Act was going through Parliament, there was a lot of pressure to get rid of adverse possession altogether, because they basically said, look, if you're registered, you're the owner, what's that got to do with adverse possession? And two counter-arguments were put forward. The first of those was that, what about abandoned land where somebody dies and nobody knows who owns it, or they move away or whatever, and you've got a piece of land that you've got a registered proprietor but you've no idea who they are and the land is just left to moulder. I have to say I think there were other ways than adverse possession of dealing with that, but that was one of the arguments. The second, and much more significant, was this: when developers lay out land, they often lay it out in the wrong place. And everybody's happy, they come along, here's my house, there's my garden wall, there's my garden fence, that's mine, that's theirs, etc. And about 15 to 20 years later, some nerd with a GPS turns up and goes, oh, well, 2.1 metres of your garden are in my land. And so what they then said was, look, if you have neighbouring land, then the position is different. And they provided an express provision, and we'll look at it in a bit more detail in a minute, for neighbouring land in those circumstances. But the point to take home from this is, forget the Limitation Act 1980 and the periods under it. Adverse possession under the 2002 Act stands or falls on following the procedures and principles of the 2002 Act, and those procedures alone. So what are those procedures? Well, let me just do a summary to begin with. If a person has been in adverse possession of registered land for a period of 10 years, then they may apply to the land registry to be registered as proprietor of that land. If, but only if, the registered proprietor objects, the squatter's still entitled to be registered if he can show that one of the three conditions, and I'll come to them in a minute, in Schedule 6 of the 2002 Act applies. And there's also a provision if he's been evicted in the last 6 months, he can still apply. The application is made on Form ADV1, and that is supported by a statutory declaration or witness statement and such additional evidence as the applicant considers necessary. Often you'll find there are all sorts of extra things, extra statements from neighbours, documents of title and all of that sort of thing. The Form ADV1 includes a section where the applicant sets out if he's going to rely on one of the three special grounds set out in Schedule 6, to which I'll come in a minute. Once the ADV1 is received by the Land Registry, they check that it sets out 10 years and things like that, but that's all the checking they do, and they then send it to the registered proprietor together with a form NAP. And that's the form the registered proprietor must return if he or she is going to object to the application. There are various other people who are entitled, like registered chargees and people like that, but essentially it is the registered proprietor alone who's entitled to have the form. And this is where things go wrong. If the registered proprietor doesn't respond within 65 working days, the applicant is entitled to be entered in the register as the new proprietor of the estate, and that happens automatically. So if you put in an application, an ADV1 application, the Form NAP is sent to the registered proprietor and he just sits on it and doesn't do anything, then the squatter will be registered without more. And that's what happened in the case of Baxter and Mannion. Mr. Mannion was the owner. He was sent the documentation. He didn't get round to filling it in the 65 days, and Mr. Baxter was then registered as the new registered proprietor. It was possible to get it out because Baxter was lying. He hadn't been on it even for 10 years, and he'd had a horse on it for a year or two. But on the face of it, he ended up being registered, and it was only by correcting a mistake that Mr. Mannion was able to get his property back. If, however, the registered proprietor does return the form and he's ticked on it that he'd like the application to be dealt with under Schedule 6(5), then the Land Registry then start to look at the ADV1 properly. If the squatter has set out one of the three grounds, then it will probably end up in the first tier tribunal. If not, the squatter's application is cancelled. And so the point is, it's a very mechanistic process. The Land Registry basically, is it this? No. Is it that? No. Is it that? Yes. Therefore, we do this. So let me now look at those three conditions. The first of those conditions is proprietary estoppel. And I don't think there's anything particularly complex about that. The second, Charles Harpham was the law commissioner who wrote the Land Registration Act 2002, and he wrote a book on why he put in certain things. And even having read his book, I don't understand. It is, the applicant is, for some other reason, entitled to be registered as proprietor of the estate. Which on the face of it, well, I'd just like to be registered, please. It's a nice estate. And what he said, he set out all sorts of wonderfully complex reasons. One is, the squatter contracted to buy the land and paid the purchase price, but the legal estate was never transferred to him. Now, I was going to say, and that happens every day of the week, doesn't it? Your clients pay in full, but the legal estate isn't transferred. My mole in the Land Registry told me they've been dealing with one recently where this has been done in try to avoid stamp duty. And apparently it didn't work. The first tier tribunal wouldn't agree to the registration at a later stage. But anyway, those first two things, apparently the second one, the Law Commission is looking at removing in any event because it's so rarely used. So you're left with proprietary estoppel and then the third condition. And the third condition is the one that covers 90% of these applications and is the neighbour one. So basically, the land to which the application relates is adjacent to land belonging to the applicant, so the applicant's got neighbouring land. The exact line of the boundary has not been determined, and for at least 10 years of the period of adverse possession ending on the date of the application, the applicant or his predecessor in title reasonably believed that the land to which the application relates belonged to him. So here you've got the reasonable belief one. So you've got to be a neighbour and reasonably believe it's yours. So it covers that situation where the estate has been laid out wrongly by the developer. You've always thought this is your garden because the fence has been there and this land's inside it. It's only when you do a GPS survey you realise it isn't. Then you're going reasonably to believe that it is your land. So the position is that if the squatter has not been in adverse possession for 10 years, he's not entitled to be registered as proprietor. If he has been in adverse possession for 10 years and the registered proprietor requires the application to be dealt with under Schedule 6.5, that is, bringing into account one of these three grounds, the squatter will only become registered proprietor if he makes out that one of those three grounds applies. So how does this work out in practice? Now, both the first-tier tribunal and the courts have adopted a very strict approach to the statutory provisions, which, to my mind, has benefited squatters to the expense of registered proprietors, with some registered proprietors losing their land. And in two of the cases I'm going to refer to, these were houses standing alone in London, so they weren't cheap and cheerful pieces of land. But the first of these, Hopkins and Beacon, the land was rather more modest. Mr. Hopkins was the registered proprietor of a strip of land which amounted to some 23.8 square metres. The strip of land adjoined a pond that separated the parties' gardens. It was useful to Mr. Hopkins, the registered proprietor, because he could use it for maintaining his newly converted granary. But equally, Mr. and Mrs. Beacon liked it because they could sit there and watch the wildlife on the pond. Mr. and Mrs. Beacon applied on Form ADV1, supported by a lengthy statutory declaration, to be registered as proprietors on the basis that they had been in adverse possession for over 10 years. The Land Registry sent out the Form NEP to Mr. Hopkins, and as the value of the land was so little, he did it all himself. He didn't employ lawyers. Major mistake to anybody dealing with land. He returned the Form NAP within the 65 days, objecting to Mr. and Mrs. Beacon being registered as proprietors instead of him. Now, Panel 5 on Form NAP has three boxes that you can put a cross in. Box 1 is, I object to the registration on the grounds stated in Panel 6. Mr. Hopkins put a cross in that. The second one is, I consent to the registration of the application. Mr. Hopkins did not put a cross in that. The third one is, I require the registrar to deal with the application under Schedule 6, Paragraph 5 to the Land Registration Act 2002. Mr. Hopkins hadn't a clue what the answer to that was, so he didn't put a cross in the box. But in Panel 6, he addressed this lengthy statutory declaration made by Mr. and Mrs. Beacon in fairly trenchant terms. So, for example, he said, the title is registered with me and they have not been in possession of the land. If Mr. and Mrs. Beacon believed the land was theirs, why did they not query their land registration title when it was issued in March 2002? Now, to my mind, that's pretty clearly saying you did not reasonably believe the land was yours. That engages Paragraph 6.5, third condition, which requires you genuinely, reasonably believe that it's yours. However, Mr. Justice Voss on appeal decided that Mr. Hopkins had not required the application to be dealt with under Schedule 6.5. Mr. Justice Voss said, put simply, I have formed the clear view, despite my sympathies for Mr. Hopkins' predicament, that the Form NAP that Mr. Hopkins served was not clear to a reasonable recipient and could easily have been construed as having deliberately refrained from invoking Paragraph 5. So Mr. Hopkins lost his land because he did not put a cross against the third question in panel 5 on the form NAP. Now, Best and Curtis is the aftermath of the Best and Chief Land Registrar saga, of which you may be aware. Doris Curtis had lived in a house in Ilford in London, and she died in 1988. She had, I think, only one child, a son, from whom she was entirely estranged. After she died, Mr. Best found her house empty, and of course, as one would, he moved in and lived there for 25 years. After about 25 years, he applied to the Land Registry to be registered as proprietor. And the Land Registry went, hang on a minute. For the last 3 months of your period, the Legal Aid Sentencing and Punishment of Offenders Act 2012 has applied. It is a criminal offence to squat in residential property. Therefore, for the last 3 months of your 25 years, you are relying upon a criminal offence, and you cannot create a right out of a criminal offence. That ended up going to the Divisional Court and then to the Court of Appeal, and both the Divisional Court and the Court of Appeal said that although Mr. Best might have been prosecuted for the last 3 months he was there, if anybody could be bothered to do so, it did not stop him getting adverse possession, and that therefore he was entitled to be registered or to apply to be registered. But as a result of the publicity surrounding the case, Colin Curtis, Doris Curtis's son, was alerted to Mr. Best's claim. Now, he had a problem. His problem was that Mr. Best had clearly been there for more than 10 years. Now, anybody can object to an application to the Land Registry, so Mr. Best could object Mr. Curtis could object to Mr. Best being registered, but of course that would fail because Mr. Best had obviously been there for more than 10 years. The only way that Mr. Curtis would keep the property would be if he could engage the special conditions in paragraph 6, because clearly Mr. Best didn't have adjoining land and could not have believed reasonably the property was his. The problem was that Mr. Curtis was not the registered proprietor, and therefore the Land Registry didn't send him a Form NAP. His solicitors ran off a Form NAP, sent it back and said, we want it to be dealt with under paragraph 5 of Schedule 6. And the first-tier tribunal said, you weren't entitled to give that notice. The only person who can give that notice is the registered proprietor or a registered chargee, and one or two odds and sods if you look at the Act. But you don't fall into any of these. And the case, if you're suffering from insomnia, read the case, because all sorts of wonderful arguments about the nature of a trust in an unadministered estate and things like that, all of which the tribunal ruled against. But the key point at the end of the day was that Mr. Curtis had got himself a grant of administration to his mother's estate, but not in time to be able to give the counter notice within the 65 days. And so the argument was, well, he wasn't able to get himself into a position within that time, and in those circumstances, it's unfair because if a person dies, then you've got to just go running around the place, and there may just not be enough time to get a grant of letters of administration to put in the counter notice. This got no sympathy from Judge Elizabeth Cook in the first-tier tribunal, who said, true it is that in a very few circumstances this may cause some practical difficulty. If the registered proprietor died on day 60 of the 65-day period for response, having failed to respond to a paragraph 2 notice, then it may be that the deadline works hardship. Hardship means you lose a whole house in London, simply because you can't get things in order. It seems to me that must be wrong, but as a matter of straight logic, it's clearly right. But as a result, the result was that Mr. Best ended up being registered as proprietor of the property. The final one, which I want to refer to, is a case called Pune Tip and Lawrence, which is so complex that, again, I'm going to summarise it slightly, and my summary isn't totally accurate, but I think it'll do for current purposes. What is even more complex about it is people kept changing their names. So somebody who started off as Ronald Kelland, I think, ended up as Mark Lawrence and things like this. So you really have to make a note. So I'll use their Christian names. Ronald and Audrey bought together and were registered as joint proprietors a house in Hanwell in London in 1972. In 1980, they separated and Ronald bought Audrey out. But they never actually went to lawyers, so they never corrected the land registry title. The result is, property is still in the names of Ronald and Audrey, even though Audrey accepts that she has no beneficial interest. Ronald then marries Jill, and they live together in the property for over 20 years, together with a long-term lodger who is a friend of Ronald's. Ronald then dies and leaves his entire estate to Jill. So the position then is, the property is still in the name of Ronald and Audrey, registered in Ronald and Audrey, but the beneficial interest all belongs to Jill. Jill leaves the lodger in the property and goes to look after her mother. At some stage after that, the lodger died, and within a couple of days of his dying, the Pune Tip family moved in and lived in the property. And they then applied, after having been there for 10 years, to be registered as proprietors on the basis of their adverse possession. The land registry clicks into gear and sends the Form NAP to the property, which is of course the registered address. Surprise, surprise, it never goes on any further than that. Now, that really does surprise me. But for various reasons I don't need to bore you, Jill did get to learn about it, and her solicitors purported to put in a Form NAP. She also rushed around and found Audrey, whose solicitors put in another Form NAP, but on about day 70 rather than day 65. The First Tier Tribunal, in summary, held Jill was not the registered proprietor, and despite the fact that the property was held entirely beneficially for her, was not able to employ the special conditions under Schedule 6, Paragraph 5, because that was only the registered proprietor. And Audrey was the registered proprietor, but she'd put in her application outside the 65-day period, which being statutory, there is no power to extend. And so the First Tier Tribunal basically dismissed that side of things. Jill did get permission to appeal to the Upper Tribunal on a very interesting point about whether the land registration rules, which allow for this sending out things by post, are actually compatible with the wording of the 2002 Act, which states that the registrar must give notice of an application. And the argument was, well, if it gets lost in the post, is he giving notice? The registered proprietor's security comes down to how good our postal service is. Permission to appeal was given on that basis, but then the matter settled. So sadly, that has not been concluded. But the point to get from it is the rigid approach of the First Tier Tribunal was not interested in the fact that this was going to dispossess somebody of a property of which they were the beneficial owner if they didn't comply strictly and simply with the statutory provisions. Let me just close with some suggestions about what you can do. Because there is such a strict adherence to the rules, and because the 65-day period cannot be extended, there are nonetheless, if you're acting for registered proprietors, a number of steps that can be taken. Now, if they're going to move into it and it's their own home, that's not so important. But quite often what happens is, this is somebody's first home. They buy a little flat somewhere. They then get married or whatever and move into a house and rent out the flat. And that's where you run into problems. It's where the registered proprietor is not actually living in the property. The first is that the Rule 1981 of the 2003 Land Registration Rules requires that the registered proprietor must provide an address for service. often this is the property itself, which strikes me, if it's not the property you live in, is not wise. Make sure that clients realise that they can and should update their registered addresses with the land registry, so that the land registry is up to date with where they actually are. As a follow-on from that, Rule 1984 allows for up to 3 addresses to be registered with the land registry, one of which can be an email address. I very, very occasionally see email addresses these days, but my advice again is give 3 addresses so that you get the notices. You're not reliant on whoever happens to be in the property sending them on to you. You get them by email or you get them to some other address. That address can be your solicitor's address. The third one is this applies particularly if, for example, the client is the beneficiary under a trust or something like that. Rule 194 entitles a person who has an interest in a property which interest would be prejudiced by an adverse possession application to apply to be notified of the application. It doesn't entitle them to serve a Form NAP, but it means they get all 65 days to go round and bully the trustees or get things in order if they're the beneficiary. So, for example, if Jill, in the case I'd given earlier, had done this, she would have got instant notice rather than learning on the grapevine at about day 50 or something of what had happened. And that might have given her the opportunity to go and find Audrey quicker and sort things out.